Here are the exact steps to sue your landlord in small claims court and actually win. Whether your landlord disappeared with your security deposit, ignored the black mold growing in your bathroom, or illegally locked you out, small claims court stands as the most powerful tool most tenants never use. Here's the best part: you don't need a lawyer. Small claims court operates as a special division of the civil court system, designed specifically for everyday people to resolve disputes involving smaller amounts of money. Filing limits vary dramatically by state, and some of these numbers will surprise you. Texas allows you to sue for up to $20,000. California recently raised its limit to $12,500 as of January 2024. Florida caps it at $8,000. Filing fees typically run $30 to $100 in most states. If you cannot afford even that amount, every state offers a fee waiver process. You simply fill out a form showing your income and expenses, and the court can let you file for free. Here is what makes small claims court especially powerful for landlord disputes. In most jurisdictions, neither side can bring an attorney. That means your landlord does not get to roll in with a lawyer who charges $500 an hour to intimidate you. It is you, them, and a judge. The burden of proof sits at just 51%, which means you do not need to prove your case beyond a reasonable doubt. You only need to be slightly more convincing than your landlord. As one legal resource puts it, sometimes it comes down to who looks like the more believable person. So, what can you actually sue your landlord for? The number one reason tenants file in small claims court involves security deposit disputes. If your landlord withheld your deposit to cover normal wear and tear, never returned it, or failed to provide an itemized statement of deductions within the legal deadline, you have a case. In California, landlords have 21 days to return your deposit. New York gives them 14 days. Montana allows just 10 days if there are no deductions. Miss that deadline, and your landlord has already violated the law. Security deposits represent just the beginning, though. You can sue for habitability issues. If your apartment lacked heat, had no running water, suffered from pest infestations, or contained structural dangers, and your landlord ignored your complaints, you may be entitled to the difference between the rent you paid and the actual value of the unit in that condition, plus any expenses you incurred, like hotel costs. You can also sue for wrongful eviction if your landlord illegally locked you out or failed to follow proper eviction procedures. And in states that require landlords to pay interest on security deposits, you can recover that interest too. Now here's where things get really interesting. The penalties. In California, if a landlord acts in bad faith when withholding your security deposit, the court can award you double the deposit amount on top of what you are owed. Colorado goes even further with treble damages, meaning 3 times the amount wrongfully withheld. Massachusetts has a similar provision. In New York, if the landlord willfully violated security deposit rules for leases signed after July 2019, the court can award punitive damages of up to twice your original claim. These penalties exist specifically because landlords have been getting away with this for decades. A study of California small claims cases found that courts only imposed penalties in 7% of cases where landlords improperly deducted from deposits. 7%. That is exactly why documentation becomes everything. Let me walk you through the exact process, step by step. Step 1. Research your local landlord-tenant laws. Every state operates differently, so you need to know your rights before you do anything else. Step 2. Review your lease agreement. Identify which clauses relate to your dispute and whether your landlord violated any terms. Step 3. Send a demand letter. Before you file anything, write your landlord a formal letter outlining what money you believe is owed to you and give them a deadline to respond. This shows the court you tried to resolve things reasonably. Many disputes end right here because most people want to pay what they owe. They just need some guidance on how to do it. Step 4. Gather your evidence. This is where cases are won or lost. Photos and videos of your apartment, especially on move-out day, often become the smoking gun in security deposit cases. Bring copies of your lease, your demand letter, all emails and texts with your landlord, and receipts for any expenses. If a friend helped you clean the apartment, bring them as a witness. Create a clear timeline of every relevant interaction. Step 5. File your case. Go to your local small claims court, fill out the complaint form, and pay the filing fee. Most courts have these forms available online. Step 6. Serve your landlord. You must formally notify them of the lawsuit, usually by certified mail or by a process server. In California, service must be completed at least 15 days before the court date if the landlord is in the same county, and 20 days if they are in a different county. Step 7. Prepare. Like your money depends on it, because it does. Bring 3 copies of everything, one for the judge, one for the opposing party, and one for yourself. Number your pages and put them in order. Here is a pro tip that most people do not think about. Bring 3 copies of the actual laws that apply to your case. The Tenants Union of Washington State points out that sometimes judges and court commissioners are not as familiar with the specific statutes as they should be. Step 8. Present your case. You may only get about 5 minutes, so be concise. Francine Levitov, a criminal attorney and legal expert, puts it perfectly. It is not about drama. Success does not go to the party who interrupts the judge or who insults the other side more loudly. Dress professionally, be truthful, be respectful, and let your evidence do the talking. And if your landlord does not show up, the court will likely issue a default judgment in your favor. You win automatically. A couple of important things to keep in mind, though. You can only sue for money in small claims court. You cannot force your landlord to make repairs or repaint the unit. That requires a different type of legal action. Be aware that your landlord can file a counterclaim, and if they win on that counterclaim, the judgment could show up on your credit report and affect your ability to rent in the future. So make sure your case is solid before you file. One more thing. Laws are changing fast in favor of tenants. California just implemented a wave of new protections in 2025, including a requirement that landlords photograph units before and after tenancy to prevent fraudulent deposit deductions. New York's good cause eviction law now caps what constitutes an unreasonable rent increase. Colorado has dramatically expanded habitability protections. Virginia is rolling out a new statement of tenant rights effective July 2025. The legal landscape is shifting, and it is shifting in your direction. Winning the case represents only half the battle, though. The court does not collect your money for you. If your landlord refuses to pay the judgment, you can place a lien on their property or ask the court to levy their bank account. Here is the bottom line. Small claims court exists precisely for situations like these. The filing fees are low, the process is straightforward, you do not need a lawyer, and with proper documentation, the odds are genuinely in your favor. Your landlord is counting on you not knowing your rights. Prove them wrong.